Dear viewers, you have asked a lot of questions for me in the comment section, and in the past we have done a lot of videos trying to find answers for the questions posed by you in the comment section. One question which did not get answered was, can somebody, be it a resident Indian or an NRI, gift equity shares to the other person? This question has not been answered. So I just thought I'll get a guest speaker who can authoritatively speak on this subject. So we have got the guest speaker today, FEMA law expert, chartered accountant Dhanush Bolar, who has done multiple videos in the past to this episode to answer your queries pertaining to gifting of shares to and from NRIs. So stay till the end of the videos. There are multiple combinations, permutations which are possible in this thing, and you have to find answer for the applicable combination that is meaningful for you in your particular case. This is NRI Money Clinic for you, and I am Dr. Chandrakant, but your financial guide for a happy living.
NRI Money Clinic. No hype, just the right advice.
Dear viewers, who can be better to talk about the FEMA law related issues than chartered accountant Dhanush Bolar? Dhanush Bolar has done a lot of videos in the past on our channel pertaining to various aspects of FEMA law, the do's and don'ts, the penalties which might come because of violation of FEMA law and other things. We have created a playlist for the videos done by Dhanush Bolar. If people who have got interest in other aspects of FEMA law can always look out for these videos in the playlist and they can refer. For those of you who are regular watchers on our channel, Dhanush Bolar is a popular guest speaker. But for those of you who are watching my channel for the first time, let me give a brief introduction of CA Dhanush Bolar. He is a practicing chartered accountant with special emphasis on FEMA law. His interest lies in practicing and solving problems pertaining to FEMA law. He is a partner at Nitin J. Shetty & Co. He has helped a lot of people who got into various issues with respect to the FEMA law. Welcome to this episode again, CA Dhanush.
Thank you.
When it comes to question of gifting of shares, the first question or the comment that will come from your side is about why you're not talking about the gifting of properties. For your information, we have done this video on gifting of properties earlier itself. I request my edit team to show the thumbnail of exclusive video on what does FEMA laws talk about gifting of properties. Those of you who have interest in gifting of properties, please do watch that video and be guided. Today's video is exclusively about gifting of shares, and we will look at various combinations in this. When I talk about the combinations, there are three distinct combinations which are here. So we will discuss all of them. Number one, a resident Indian gifting to an NRI. The second case is an NRI gifting to a resident Indian. And the third case scenario is an NRI gifting to another NRI. Now let's get the right answers from the speaker today. Dhanush, my first question to you is, can a resident Indian gift equity shares to an NRI?
See, when a resident or a non-resident gifting equity shares of Indian company or a foreign company, it's very important to keep in mind the provisions relating to Foreign Exchange Management Act, known as FEMA law, and the requirement of RBI approval. The first question is about the gifting of shares of Indian company by a resident to NRI. Yes, a resident can gift the equity shares of Indian company to the non-resident with the prior approval of Reserve Bank of India. So there is a limit, but for one share also it requires approval of Reserve Bank of India.
It means there is no automatic route here. If it has to be transferred, it's possible, but you have to request for RBI permission.
Yes. RBI approval is mandatory.
I understood this point, but at the time of transfer, are there any thresholds or limits or limitations which have been put under the law? I can do only so much, or you can do unlimited. What does the law say about it?
See, there are two limits here. The first limit is with respect to paid up share capital of the company. The value of the gift shall not exceed 5% of the paid up equity share capital of the company, and this limit is a lifetime limit for a particular donor. And the total value of the gift by the donor to the donee, who is an NRI, or to any other NRIs, shall not exceed equivalent value of $50,000 per financial year. For this, we have to consider the fair value of the company.
So in your earlier case, you said it is the paid up capital, 5% of the paid up capital.
Yes.
Which is a fixed value.
Yes, it's a fixed.
Whereas here it is, you say fair value, which
Fair
means either by market determination or the specified way of finding a fair value.
Yes, yes.
$50,000 per year, or is it a lifetime limit?
This $50,000 is per financial year and per donor. So the total value of the gift by the resident in a financial year shall not exceed $50,000. It can be to a multiple recipient.
So the total limit is per donor.
Yes.
Whereas the recipients could be multiple.
Multiple, yes.
I'll tell you a case example now. There is a parent who is husband and wife,
Yes.
and they have their only son living outside of India who is an NRI.
Yes.
The father can give $50,000 worth of equities to his NRI son. Likewise, mother can also give 50,000.
Yes.
So limitation is at an individual level.
Yes.
Suppose if the parents had 2 children,
Yes.
then across 2 children put together, it cannot exceed
50,000, exactly.
Correct?
Exactly.
Now, one another question is, now we talk about relatives when it comes to the question of gifting. See, the rules and regulations around gifting involves you can gift it to a relative or a non-relative. So how does the equation of relative work in this case?
See, here also a resident can gift to a NRI who is a relative as defined under the Companies Act. So the Companies Act covers only spouse as a relative and the siblings, parents and children. So if a grandparent wants to gift to a grandchild, it is not permissible.
So it has a very restricted number of people who can receive the gift.
Yes, yes.
Dhanush, let me pick up some more additional points around this now. We talked about the equity shares. That's a direct equity share.
Yes.
Equity shares can also come in the form of indirect investment. For example, in case of mutual funds or an ETFs or something like that. So can a resident Indian gift mutual funds, ETFs, etc., which fall in that category to a NRI?
See, in our earlier episodes, I always tell whenever there is a cross-border transaction, one has to keep in mind the FEMA law. For gifting of mutual fund units, there is no specific rules under the FEMA law. So in the absence of such rule, it is better to take a prior approval of Reserve Bank of India, then execute the transactions to avoid any litigations or any legal consequences in the future.
So as per your opinion, if the law does not specifically permit certain things, do not assume it as an permission already given. Rather seek clarification, seek permission from RBI, make sure that in future something will not go wrong.
Yes, exactly.
One another issue that comes to my mind is, these days, a lot of people invest outside of India. They send money by LRS route. It's common. It's not something, it is one-off event today. So you see a large number of Indians investing outside of India, which could be again in equity direct outside of India. In such a case, if a resident Indian is holding equity shares of a foreign company outside of India, can they gift this to another NRI?
See, for this also, there is no specific rules under FEMA permitting these transactions. So it is better to approach Reserve Bank of India for the approval to avoid any legal consequences. However, there is one exception wherein that resident would have acquired the shares when he was a non-resident. So now he has come back to India for permanent settlement. So he will be considered as a returning Indian. In that case, he can gift the shares to another non-resident. So that is permissible. Only for a returning Indians is permissible. Otherwise, for resident, gifting of shares of a foreign company to another NRI is not permissible.
So in my understanding, in that case, if a foreign equity shares are held by a resident Indian, what matters is how did you acquire it? Did you acquire it as a resident Indian, or did you acquire it during your stint as an NRI?
Yes.
If you have acquired it when you were an NRI, then it is permitted to be gifted.
Yes.
However, you have sent money outside of India through LRS route, you have acquired these shares, then you are not allowed to transfer it and you need to seek RBI
approval. Yes.
Right. Dhanush, now let us look at the reverse scenario. We discussed till now about a resident Indian gifting it to an NRI. Now let us look at the reverse of it. What if an NRI is gifting it to a resident Indian. Can an NRI gift equity shares to a resident Indian?
Yes, this is permissible. Under the FEMA rules, NRI can gift the equity shares of Indian company to resident Indian. And here, resident Indian need not be a relative, whereas
It need not be a
need not be a relative as per the definition provided under the Companies Act. She can be any person. We don't have to check the relative definition here.
So the taxation will involve, that's
Yes,
as per the income tax,
income
whether
tax,
it's a
yes.
relative, if it is a non-relative, whether it is taxable gift or whatever it is, that is decided by the income tax.
Yes.
But the transaction is permitted
Permissible without the approval of Reserve Bank of India.
and need not be a relative.
Yes, need not be a relative.
What about the other forms of stock market instruments like mutual funds and ETFs? Can those also be gifted to a resident Indian by an NRI?
Here also the same provisions will apply. FEMA rule does not explicitly provide for such transactions. So in the absence of such transactions, it is better to seek Reserve Bank RBI approval for executing that transactions.
So in your earlier case, you said it is clearly mentioned in
Yes.
the law that the equity shares can be transferred.
Transferred.
That's mentioned in the law.
Yes.
Whereas when it comes to question of mutual funds and ETFs and kind of things, it is not mentioned.
It is not mentioned.
Since it is not mentioned, it is better you write to them, get a permission, and then you do the gifting.
Yes, correct.
Right. Now the last of the variant. NRI is holding shares of foreign companies.
Yes.
Can they gift it to a resident Indian?
Yes, NRI can gift the shares of a foreign company to a resident irrespective of the relationship. So here also we don't have to check the relative definition. However, one has to keep in mind what can be transferred by way of gift. The shares of only those company which is engaged in a permitted sector. That means to say, if that foreign company is engaged in real estate activities, that is trading in immovable property, then such gifting of shares of that foreign company to a resident is not permissible. So only those sector, only shares of those companies which is engaged in the permitted sector is permissible.
Dear viewers, we are making every attempt to give you the exact answers around gifting of shares or various other taxation rules. But please understand one thing, these are very complex issues. There can be variation which are applicable to individual situation. Let's say that you have to take an action around gifting of shares. I suggest you to check with the concerned professional FEMA law experts before you get into the transaction. I would like to add a disclaimer here. Please do not base any of your decisions based on what we have discussed today. It's a points of law as interpreted by my guest speaker today. When you take an action, you must be consulting proper professional, explain your individual situation and let them give you the right answer. Dhanush, thanks for these answers. Now let us look at a third combination, which is gifting of shares between an NRI with another NRI, right? First question, can an NRI gift Indian company shares to another NRI?
See, answer to this question depends upon the intention of the recipient of shares to hold it on a repatriable basis or a non-repatriable basis.
So there are two variables which will come here.
Yes.
So if somebody has purchased it on NRE
Yes.
and he has acquired it from his PIS account,
Yes.
so they will come under repatriable basis.
Repatriable
If
basis.
he has acquired it from his NRO account,
Yes.
then it will come on a non-repatriable basis. Good. So we have two more variants to add to the complexities now.
Yes.
So what does the law say?
So if the recipient wants to hold the shares on a repatriable basis, that is to his NRE demat account, then he has to go to Reserve Bank of India, get the approval to receive the shares in the form of gift. Here also the same limit will apply. The gift shall not exceed the 5% of the paid up equity share capital of the company, and the total value of the gift shall not exceed 50,000 USD per financial year, and he has to be a relative as per the definitions provided under the Companies Act, that is the spouse, siblings, parents and children.
So all three conditions will come. Only
Yes.
a relative can do it. Maximum limit of $50,000 US,
Yes.
and the paid up equity capital not to exceed 5% of
Yes.
total paid capital throughout the lifetime.
Yes, throughout the life.
Those conditions will apply.
Apply.
This is with respect to on a repatriable basis.
Yes.
Are there conditions which are binding on non-repatriable basis?
So if he intends to hold the shares on non-repatriable basis, that is to his NRO demat account, then he need not go to Reserve Bank of India to receive the gift of equity shares. It is permissible without the approval of Reserve Bank of India.
So it is just treated like two individuals
Yes.
within India. So the money will remain within
Remain in
India.
India. Yes.
So it need not be permitted by RBI on a specific case-to-case basis.
Yes.
What does the law say with respect to gifting of mutual fund and ETFs between two NRIs?
The same law will apply as we explained before. There is no specific rules permitting this transaction. So in the absence of such a specific rule, you have to go to Reserve Bank of India and get the approval for receiving gift of mutual fund units, ETF or any other securities.
What if the NRIs are holding shares of foreign companies? Both are living outside,
Yes.
two NRIs. They have purchased it outside of India. Can that be gifted to another NRI?
See, this will not come under the purview of FEMA law because it's not a cross-border transactions. Because they are resident outside India, even the shares is of a foreign company. So it will not come under the purview of FEMA law. So it is permissible. Only thing is they have to keep in mind the laws of the host country. That is the country of the company where it is incorporated.
Right. So viewers have to keep in mind whenever they are gifting shares, irrespective of whether he is a resident Indian or a NRI to resident Indian or a NRI to NRI, the best way to figure out is, does it result in a cross-border transfer of money?
Yes.
Right, India to abroad or abroad to India, in which case the FEMA law will apply. And you have to look into what does the law say, consult the professional,
Yes.
make sure, doubly sure, triply sure that you are not violating the FEMA law.
Yes.
But if it is a transaction which does not have a cross-border implication, that means you have purchased it outside, you are living outside, the person whom you are gifting is living outside, so it happens outside of India, the FEMA law does not apply in that case. To that extent, that is where it remains very simple.
Yes.
One last question with this different combinations is, while we discussed three different possible scenarios, there is a possibility of a fourth scenario,
Yes.
wherein which a resident Indian is having the foreign equity shares with him, which he has acquired by sending money outside of India. Can he gift this to another person who is a resident Indian?
Yes, this is also permitted. So the resident who had acquired the shares of a foreign company under the liberalized remittance scheme can gift such shares to another resident provided he is a relative as per the definition provided under the Companies Act.
So the restriction here is it can be given only to a relative, not a all and sundry.
No. It has to be to a relative.
Dhanush, there is so much complexity. There are so many combinations, relative, non-relative, NRI, resident Indian, cross-border, a maze of rules, and you cannot help it. But my worry is, what if somebody has done a gifting without knowing any of these rules, regulations, complexities? The person did not bother to check with a professional and they did a gift and it is a violation. What consequence will follow?
So if the gift is done which is not in accordance with the FEMA law, then there is a possibility that the transactions may be deemed invalid, will attract penalty which may go up to 3 times the values involved in the contravention. You may have to get approval from Reserve Bank of India, which may or may not happen.
You mean to say that it has happened and you ask for a permission with retrospective effect?
Yes, with the retrospective effect.
That's complex.
Yes,
Right.
it's a complex procedure. So it's always better to keep in mind the FEMA law, then understand the law, check whether it's permissible or not permissible, then execute the transactions.
So dear viewers, one thing is very certain. When it comes to question of FEMA law, don't take anything for granted. It doesn't cost you a great deal of money to check with the concerned professional what you're doing is right or wrong. Instead of that, you assume, you get into some transaction, somebody will say, it's okay to do that. We will look at it when the time comes. Probably it may come back and haunt you with a huge penalty and unwanted consequences in your life. Avoid that. Wherever cross-border transactions are involved, always take the guidance of the chartered accountant who are conversant with the FEMA law of the land. Dhanush, thank you very much for all these points that you have discussed. And it's a great news even for me. When you're discussing, I myself was amazed at the way the complexities which involve. Thank you very much for your time. I remain in gratitude to you. Thank you very much.
Thank you. Thank you.
Dear viewers, hope the video that I have done today helped you to understand few of the complexities and the rules and regulations pertaining to gifting of equity shares between NRI and residents or between NRIs and NRIs. If it has given answers to the lingering doubts that could be there in your mind, please do give me a thumbs up. If you have not yet subscribed for my channel, please do hit that subscribe button and press the bell icon. Do not forget to share these videos with your near and dear ones, friends and relatives, and on all the social media handles on which you are connected with. Thank you very much for watching this episode on NRI Money Clinic. I shall be back with you next Tuesday with yet another expert, with yet another useful topic. Till then, stay safe. Jai Hind.
Press the bell icon for more details and subscribe our channel.